Oh, now I really work. Okay, ladies and gentlemen, thank you all. I really appreciate everybody being here. Tis the season to try to get bills through, and with crossover day approaching, I understand that we sometimes have to have, and with session going long yesterday, we sometimes have to have creative times for our committee meetings. I appreciate everyone's attendance here today. First up is going to be Representative Price. We'll hear HB 166. Representative Price.
Thank you, Madam Chairman and members of the committee. This is House Bill 166, LC 410927. This was filed in 2017, and it did receive a hearing last year with no vote. It regards the area of exemptions for jury duty. And in this instance, the change requested is to provide consistency in the code, number one, and number two, relief for working families who want the best for their children. The history of jury duty exemptions goes back to 1984 when the legislature repealed all the jury duty exemptions. In 2008, there were some exemptions added that qualified under 1512 1.1, persons or excused or deferred. And the reasons, some of which are at the discretion of the judge or specified in code, include anything related to public health, safety, good order, and good cause. And most notably, for cause, a student it can be exempt. Primary caregivers of children less than 6 years of age can be exempt with an affidavit. Primary teachers or homeschool teachers also can be exempt with affidavit. Primary unpaid caregivers for disabled greater than 6 years of age, again with an affidavit. Anyone over 70 years and anyone in the military or active service duty. So this boils down to how it affects Georgians is that parental choice should include what's best for working parents. And working parents have a number of options for their children under the age of 6. And some prefer when they have to work and are not able to be with their children, which is probably the best thing for the children, and they may not want to have them in a large institutionalized setting, which in these days we have more fears of institutionalized settings. So they would prefer a small, nurturing, safe environment, and one that has essentially a surrogate parent figure in the role of being with them all day. So there are a number of private homes that offer themselves up, and they keep up to 6 children in these settings, and they are licensed by the state of Georgia, and they're called Family Child Care Learning Homes, FCCLH. And these are licensed, as I said, through the state, through DECL, Department of Early,
Okay. That would be DECAL, the Department of Early Care and Learning.
Department of Early Care and Learning. And there's so many acronyms that I'm learning. Anyway, this group, FCCLH, has requirements upon them to provide this setting for children, and there are approximately 2,000 families that offer their homes for this, which, if they are allowed to have up to 5 kids in there at the same time, that can affect approximately 10,000 families, and if you say there's 2 parents in each family, it's over 23,000 working parents who could be affected that are trying to stay in the workforce and are relying on these FCCLH homes. The pay for those homes is barely covering expenses, and if they had to leave for jury duty, they would have to pay a substitute. Again, the state requires the substitute be trained. They have to be fingerprinted. They have to be knowledgeable in CPR and approved in advance by DECL. So it's very difficult for a family care provider to find a sub and make it financially able for them to do it. So when some of these folks have been called to jury duty, they have scrambled to try to find an appropriate and acceptable substitute. If they tell their parents that they can't be available for the children, then the parents may go elsewhere. It just may totally ruin their business. And also, bringing a substitute into their home is very disruptive to the children. The fact that they were chosen to have a setting that would be not disruptive to the children then would lead to a difficulty in, you see a lot of acting out in the children when they don't have consistency. Also, having a substitute into a private home is a liability factor for the family child care learning home providers. So we, last year at the hearing, had a number of people come to speak from these different agencies, area groups, PFCCA, Professional Family Child Care Alliance, and a number of testimonies and letters of support, a petition of 155 providers or advocates, 5 letters of testimony, and one of our members in the Senate here has children in one of these settings and has provided a letter as well. What are the drawbacks, and who criticizes this change in the code? Well, some people would say that it's a business and therefore not a family member or parent, but the reality is they're more a surrogate parent than a business, and they certainly don't make very much money. Other criticism is that it takes away from the jury pool, but this really would only affect about 3 out of 10,000 people. And then, of course, the old criticism, another group just trying to avoid jury duty, but this has not been shown to be the case. In some of the testimonies, these folks are very much willing to do that in a deferral situation, or as such time as they don't have that requirement or obligation to these families. So in summary, I think this bill would very much support working families. It would provide a safe, consistent, loving learning environment at home and consistency in our code, since our other 2 groups are almost identical in terms of the definition in the stated exemption. And I think that as a state, we should value high-quality child care and support and encourage these situations as opposed to putting up roadblocks in front of them to make them less likely to be an option for parents.
Okay. All right. Thank you, Representative Price. I appreciate that. Representative Cantrell has a question. Are you?
Thank you. Okay, there we are. Thank you, Madam Chair. Representative Price, thank you for bringing this bill. My question is, and forgive me if you said this in your presentation, but I don't think you did, do judges currently not have this discretion?
They do, but it's inconsistently applied. For instance, one family member indicated that she was number 800 on the jury pool and thought for sure that she wouldn't be called, didn't notify her families that there was a potential of her being called, and then at the last minute, she was called and she was not given that opportunity. And this happens repeatedly, that there is not consistency in how the judges apply it. Many are understanding and do grant that excuse, but there's no consistency and they can't count on it. Therefore, if they have to notify their families and they may or may not even have to serve, they'll find out the night before, as you do when you call.
Sure.
Or they may find out that it's a lengthy trial and they've got a long term away from their home, and at that point, the families that come bring their children there may just say, well, I'll find someplace else. They come back from their jury duty and they find they've got no children left at all. So it totally affects them and their occupation. But moreover, it's a scramble for the other parents as well.
Follow up, Madam Chair?
Sure.
I get the idea of trying to protect working families. I get that. But what's best for them? But what's best for our system? Aren't these exactly the kind of people we want to serve on our juries?
I would say yes, but I'd also say they're exactly the type of people we want looking after our
exempt.
children.
Fair enough.
Thank you, Representative Cantrell. Representative Lott.
Thank you, Madam Chair. My question, and I guess it's sort of along the same lines, I had the same flexibility question that the courts may already have. But my second question is, this is the same discussion that we have in healthcare a lot. And I have a concern that we're picking and choosing from the state level rather than allowing the courts to use that ability that they already have. I hear this regularly from physicians, single practice owner physicians, that they have this same obligation. They have patients, and I know you do as well in your area. I'm not sure that I think we should be dealing with this here.
Well, I guess the response to that is in many occupations, you have the option to defer, and you can find a date somewhere to defer to. And in these situations, these folks don't take vacations. They don't take days off. They just don't. They're 100% committed, and they may accept a deferral, but it may be years in advance in the future when they would not be doing this anymore. But in the current time frame, a deferral just isn't an option, as it may be in a number of other professions. But the real issue here is the consistency and the exceptions that are already in the law, because this group is virtually identical.
Yes, ma'am. Thank you.
Thank you, Representative Lott. Representative Spencer.
Isn't it true that members of the General Assembly are exempt from jury duty during session?
I don't know. I was called for this week, actually, and I got a deferral for April.
Mm-hmm.
But
Well,
I don't know that we are.
we are exempt from jury duty during the session, so. No, we're exempt from jury duty during the session. That's what the code says. Outside of that time frame, we are not exempt. So I think if the exemption's good for us, it's good for folks that are providing care to children.
Thank you.
Thank you, Representative Spencer. Any other questions for the presenter? Representative Price, do you have anyone else to speak to the bill?
Due to the short notice, I
Okay.
notified folks, but I have not heard back if anyone
Okay.
is coming.
I certainly understand that. And just for clarification, the bill does relate basically to parity. So what are those two groups or two or three groups that are already exempted in current code, and we're trying to add the family child care members?
It's primary caregiver less than age of 6,
Mm-hmm.
and this group is restricted to less than age of 6. And also primary teachers in a homeschool setting, or in other words, homeschool teachers.
Okay.
So this would be essentially a surrogate parent in a home setting.
Okay. All right. I appreciate that. So the bill is now with the committee, having closed off testimony. What is the will of the committee? There is a motion from Representative Spencer. Do pass. Is there a second? There is a second from Representative Cox. All those in favor, please signify by saying aye. Aye. Any opposed, like sign? There is one in opposition. So the motion carries. Thank you, Representative
Thank you very
Price.
much.
We're just going to go down the list for the rest of the cases, or the rest of the bills that we have on the agenda. The next is House Bill 242. However, for planning purposes, the chair is very cognizant that it is 8:17, and she is a member of Rules, as is some other members, probably have business with the Rules Committee as well. So brevity is appreciated at this point. Representative Prince.
Thank you, Madam Chair. I will be brief. House Bill 242 basically talks about the Protecting the Military Children Act. This is a bill that stemmed from a working committee that I'm on with the Military Affairs, and this is something that we think could help our military installations, the communications between child advocacy centers and the military bases. Basically, to be brief about it, you go to line 41 is basically where we start the major changes. And basically what it asks is that the child welfare agencies if there's a possibility of neglect or abuse of a child, to determine the military status of that parent or guardian of the child. That's usually going to be done around military bases, i.e. Fort Gordon, places like that where you have military people who live off base. From there, if it's determined that the member or the parent or the guardian is on an active duty status, that they were asking the Child Advocacy Agency just to notify the Family Advocacy Agency on that post. That makes sure that they are aware of it. And that sort of is in concert with what DOD is doing. If you go to DOD section 1787 of Title 10, it states that the Secretary of Defense shall request that each state provide for some reporting to the Secretary. In a report the state receives of known or suspected incidents of child abuse. So basically what we're trying to do is just basically close that gap to saying that child advocacies, if the child of a active duty military person has been abused or accused of a neglect, that we notify the Family Advocacy Center on that base to make sure they are aware that to help track that child as they move across the country with their parents.
Okay. All right. Thank you, Representative Prince. You have a question, Representative Spencer.
Thank you. As you know, I represent Kings Bay Naval Base, so I have a lot of military families in my community. Kind of help me walk through this. What if, oftentimes deployment puts a strain on families, and the young mother is at home with children, and things aren't going well with mother and the active duty husband who is out in a submarine somewhere in the ocean. Let's say things didn't go well and the mother alleges abuse of a child. What happens in that case when, does command get notified of the alleged abuse while this active duty person is out in a submarine somewhere? And I'm just trying to think what's happening, in the relationship between these families. And so things can get pretty testy. And so my concern is, what happens? Does this get notified to command, to the person's command?
No, this
the
is
active duty. When they report this status to the child advocacy or military family advocacy program on base, what happens? How does that work?
Well, I'm not sure about all the details, but what would happen is, again, this is not saying that the parent is the abuser, okay? This is just if the child is reports abuse. It could be at school, they could be at their school, usually somewhere that's off the military installation, and what we're asking the Child Advocacy Center, the civilian side of the house, just to notify the military side of the house so that they would at least know it and that they can track as far as the military side, for the DOD side of the house. So that's what that is. As far as notifying the soldier or the person who's off at sea, that would be whatever procedures that the family advocacy on the military side they follow. And I'm sure they will at least notify the chain of command.
If you don't,
Yeah.
But my concern there is, and I treat a lot of military families in my own line of work, and I see the social pressures that are placed on these families, as you probably could imagine. And sometimes things get testy, and they throw things around like that. And my concern is, if it's told to the advocacy center on the base, that obviously has to go. That reaches a level of concern that reaches this person's command, and that command will have to address that with the active duty person. That may be. I just see some concerns there.
Well, being a former commander myself, if that is the case, if the service member is the person that's being accused of neglect, yes, it is the chain. I mean, they should. That's their job, to make sure they address that. However, as I said here, this is not say that the soldier or they are the person, or the parent or the guardian are the person that's being accused here. It's if that child could have been abused by someone, a school teacher or someone like that. We just want to make sure that the Child Advocacy Center on the military installation knows about it. Now, what they do as far as reporting and things like that, who they report it to, you know, that's I don't think it doesn't automatically go to a chain of command. It would probably go straight to the parents, because again, especially if the parent or guardian is not the person being accused, it doesn't have to get in the chain of command.
Thank you, Representative Spencer. Representative Rakestraw.
Thank you, Madam Chair. So is the purpose of this bill to make sure that if they suspect some kind of abuse in the home or wherever, I would think more in the situation in the home, that they kind of stay on the grid nationally as they move around the nation, so that they don't lose sight of them from state to state, because most of the services and, you know, like DFACs are handled from one state to another. Is this just to kind of keep them on the grid?
Exactly.
So that somebody's following up to make sure that it doesn't continue, or there's no other cases reported? I mean, is that the purpose of this bill?
Yes, ma'am. That is exactly the
Okay.
purpose.
Thank you.
Thank you, Representative Rakestraw. Representative Lott.
Thank you for bringing this bill. I have as well many military families in my community that do attend public school. And I wanted to ask this question because I don't understand the military very well, having not really been in that myself. But so does this family advocacy program, do they keep up with our military children regardless of complaint?
Yes, they do.
So
If
this
it's
is just,
excuse me.
oh no, go ahead.
I'm sorry. If the person is on active duty, yes.
Okay, so follow up if you don't mind. So this is to make sure that whatever is happening in my public school systems is just to make sure that there's some communication between the two.
Communications is the word. Yes, that is
Great.
correct.
I appreciate it. Thank you very much.
You're welcome.
Thank you, Representative Lott. No other questions from the committee. This was just for a hearing, but I would suggest, Representative Prince, if you would like to follow up with Representative Spencer on some of the repercussions of a report, that would probably be beneficial. If you would like, it's your call. I appreciate your coming this morning and presenting to the committee. We are going to hear. Okay. Yes. Okay, we have the correct 982. I'm sorry. We are going to go on to House Bill 972, LC 297906ER. Representative Chairman Willard had to be at another meeting this morning, just like Chairman Nimmer. So in lieu of Chairman Willard, we're going to hear from committee member Mary Margaret, Representative Oliver. She's going to be presenting the bill.
May I do so from chair, Madam Chair?
That's fine.
Good morning, ladies and gentlemen. House Bill 972, and I'm working from a substitute that's in your folder, 297967 ERS, is brought to us from the Department of Family and Children's Service primarily for the purpose of matching Georgia's independent living program for foster care aging out children 18 to 21 to the federal statute and oversight specifics to allow Georgia to pull down federal money. As you know, children who are in foster care, if they meet specific federal requirements, and they are detailed about how the state oversees foster care for children under 18, there is a significant federal reimbursement to the state if the cases are managed in compliance with federal regulations, which are pretty detailed. We have expanded our independent living program for children 18 to 21, as about half the other states have done, and we have expanded it for several years in a way that has provided financial supports and opportunities for 18 to 21-year-olds to continue vocational educational programs. We are bringing this bill, the state DFACS is bringing 972 specifically to make the program that exists today fully in compliance with the federal regulations in order to get the reimbursement that Georgia's children are entitled to. I've handed out for you a packet of materials that are pretty convincing on the way in which foster care children aging into young adulthood, 18 to 21, need support in the way your children need support. They don't have anybody who's going to help them fill out college applications, apply for the make the application, get a driver's license. It's pretty, I run into these children pretty often who, for their good own advocacy and the advocacy of Empowerment Group, which is a group that helps foster care children in that young adult status, who are out there totally on their own trying to piece together resources to go to college. And if they are able to do that, obviously they have a much greater opportunity to succeed and transition into young adulthood. Specifics of the federal oversight program that bring Georgia into compliance begin with a definition of receiving extended youth services from DFACS in Section 1. It grants in Section 1.2 specific jurisdiction to the juvenile court. The federal regulations do require a court oversight of a specific independent plan. It requires only one hearing a year, so it will not greatly grow the work of the juvenile court judges. There are about just under 700 children today that are receiving these services, but it does, in lines 31 to 41, give jurisdiction to the juvenile court for this oversight. It also sets some timelines by which, the foster care youth, who is now an adult, legally adult, volunteers to become a part of this program. It's not mandatory. It's, I hope, foster care workers urge children who, again, are legal orphans. They do not have family. They do not have parents. They may have a permanent plan of living with a distant relative or with a foster care family, but they are legal adults, so they have to volunteer to participate in this program. And the volunteer criteria, if they volunteer, there are specific criteria set forth in lines Section 4A, beginning on lines 70 on page 3. They have to either be in school, vocationally, or college, or work, or be part of a specific transition plan. The plan has to be developed within 30 days of them becoming a legal adult, again, based on their volunteer, their wish to be involved, and it has to be approved no later than 120 days later. All of these specifics of timelines and criteria and jurisdiction oversight by the juvenile court are, again, required by the federal regulatory scheme for independent living, and will allow Georgia to be reimbursed for federal money, which is extremely helpful in funding this program. And specifically in lines 153 to 155, it sets out the extended care services for the purpose of receiving federal funds specifically. Madam Chair, we have a young woman with us who has participated positively in this independent living program, Ann Campbell. She has resided in apartments with supervision with an educational program, and she's now 23, and it's a good example of the success of this program. For children who are legal orphans, have no adult responsible for them, and have been in foster care, this program, bridge program, transition program, is very positive. It's really necessary supports, and the purpose of 972 is to allow Georgia to get maximum federal reimbursement. I'm happy to answer questions, Madam Chair, or I believe there are some people who may wish to stand and support this program, however the Chair wishes to proceed.
Thank you, Representative Oliver. We'll see if any of the committee members have any questions for you, and then we'll see if there's any comments from the committee or any comments from the public. Representative Cox has a question.
Just real quick, on page 3, there's two ways the program can terminate, it appears to me. Obviously, the child becomes no longer eligible in subparagraph D, and subparagraph C on line 86, the child can terminate it. As you mentioned, it's voluntary, so the child can terminate it. In subparagraph D, it talks about sort of how the agency will notify the child in writing or electronically, you're no longer in the program.
Mm-hmm.
Are there any requirements of how does the child sort of notify that they're no longer wanting to participate, and how do they exit are there any other requirements when they exit the program voluntarily because they kind of had enough and want to move on their own?
It's interesting, some of these young people at 18 believe they are fully
Well,
adults and they're tired of caseworkers. And
Yeah, I've seen that in my own family. So.
it happens. It happens. All of these young people in the independent 18 to 21 do have a caseworker, a specialized caseworker for independent. So I think there is a keeping tabs on, are they in compliance, are they in school, or are they working? And I feel like that kind of communication, I'm glad to see statutes now saying electronic notification is sufficient, but I believe the caseworker oversight is there if the child decides I'm done with college and I'm going to join the whatever.
And that's it?
Yes, sir.
Okay.
Totally voluntary.
Right.
Voluntary by the young child, or the 18 to 21-year-old. In the state, it's has to oversee to see if they're meeting the eligibility requirements.
Gotcha.
Thank you, Representative Cox. Representative Rakestraw.
Thank you, Madam Chair. I just wanted to say I applaud your effort to bring this bill, because one of the alarming statistics that I heard when we went on the bus tour for sex trafficking was that 90% of the people in the sex trafficking industry are people that have aged out of the foster care system and don't have anywhere to go, and so they're like prime targets for these traffickers. So I want to thank you for bringing your bill, and at the appropriate time I'd like to make a motion.
Okay. All right. Are there any other questions for the bill's author? Seeing none, are there any members of the public who would like to be heard on the bill? Yes, ma'am. Please take the podium. Please state your name for the committee.
Ann Campbell.
Welcome.
Good morning. Good morning, representatives. My name is Ann Campbell, and I myself have aged out of care. I would like to talk about the positive side of having benefits beyond the age of 18 and how it is still helping me to this day. While transitioning in care, I fell homeless without my caseworker's knowledge. My placement at the time told me to remove all of my property from the home. During that time, I had recently turned 20 years of age. Out on the streets with nowhere to go and still struggling to be a college student, the benefits I received at 18 and beyond really helped me. I was experiencing a lot of health issues, and I was very grateful that I had my mental, medical, and dental insurance. These services made a difference for me in my years, and these services made a difference for me in my years, and I know that it will continue to make a difference if it stays. We were all 18 and up before. Our brains are not fully developed until our mid-20s, but the system is wanting us to grow up faster than our brains. With this bill, we can keep kids off the streets and more educated and hardworking youth. Thank you for the opportunity for allowing me to speak this morning, and I hope you will support this bill because it will truly make a difference. And I do also have as well a small copy of what the bill would
Okay.
look like.
Thank you.
If
Do you have copies for the committee?
Yes, ma'am.
Okay. All right. If you'll hand that to Michelle, she will pass that out to committee members. Any other members of the public wish to speak to the bill? Okay. Hearing none, there has been some concern raised as to the fiscal impact of the bill. So we are going to hold off on a vote on this bill. I do apologize. But there is some concern with regards to the fiscal impact of the bill. We do have a committee meeting scheduled for Tuesday, so it hopefully will not hold up the bill through the process, but we will be holding the bill. Yes, ma'am.
George is spending this money now. The point of this bill is to get reimbursement. So the fiscal direction of this bill is to enhance money, not to take money away.
But once it's codified, there could be a lot more children that avail themselves to the services. I would like to be cautious before and have some more thought and process and input as far as the fiscal impacts.
Thank you.
Thank you. So moving on, House Bill 982. I'm going to be presenting that bill. I'm going to be handing the chair over to Vice Chair Cox. Yes.
Madam Chair is going to recognize Chairman Ballinger to present the bill.
Thank you, Chairman Cox. I appreciate the opportunity. House Bill 982. I think I'm working from the wrong LC number. Matt, can you give me the right one? Yep. Nope, that's Wendell's bill. Okay. Yes, okay. I am working from LC 297935, House Bill 982. This is a bill that basically kind of streamlines some of the processes through DFACS. As many of you know, Representative Nimmer, Chairman Nimmer, is a, a foster parent and has become very passionate on this issue and has partnered with DFACS. On lines 15 through 21, basically it codifies what the court would find within 6 months of the date of the child's removal from his or her home, that a diligent search has to search for a family member, any relatives or fictive kin who are willing to provide a permanent home for such child, and that if such child is living with a foster parent in a stable home environment, that a removal of such child from a foster parent would be detrimental to a child's emotional well-being. The court may excuse DFACS from continuing the duty to search for relatives or fictive kin. And on line 46, there's some updated to the language and some changes that had to be made due to insertions. And on line 46, pursuant to a court order, the child has been in foster care under the responsibility of DFACS for a cumulative period of 12 months or longer, and the parent substantially neglected or willfully refused to remedy the circumstance that caused the child to be in foster care. And if a petition to terminate parental rights has been filed by another party, DFACS shall seek to be joined as a party to such petition. So we're just really kind of wanting to kind of draw down the timeline and streamline the processes through DFACS. I will be happy to answer any questions.
Looks like you do have a question from Representative Oliver.
Thank you. Another bill came through here, a portion of another bill in relation to termination of parental rights, and I don't know where that bill is right
It's currently in rules. It should pass out and be voted on Monday.
And does this bill change that provision in relation to termination of parental rights?
No, ma'am, it doesn't.
It seems to put some, particularly on line 46 to 49, I'm sure there's some people that have looked at this to see if it really defines termination of parental rights criteria differently, but that's perhaps an ongoing discussion.
Mm-hmm.
Any other questions from the committee? Seeing none, Representative Rapsberger.
On line 15, I see that it says within 6 months of the day of the child. How is that date set?
Well, it specifies the date of the child's removal from their home. So it's six, you know, the time would start ticking whenever the child is removed.
So what we're saying, though, within 6 months, then you're not looking for any blood relatives? That's my
No, you
concern.
have 6 months to find relatives.
Does that not seem a little short for a blood relative?
How much time do you think the department should be granted to find a relative?
I think blood is very important. And it's blood relatives, not just fictive kins. And I just think that to be tied, blood relative to be on the same plane with fictive kin just seems to me just a little bit too short. I would like to see 12 months there.
The intent of the bill is to grant permanency to children who've been removed from their home. These are children who, through no fault of their own, are going through a tremendous period of upheaval and transition. And so we are trying to give some clear policy guidelines and some deadlines so that the children can be placed and enjoy a permanent home.
Looks like I have a question from Representative Collins.
Thank you, Vice Chairman Cox. On line 16 through, line 15 through line 17, it talks about, just as we discussed, the fictive kin and blood relative. help me understand this. If we walk this out and let's say that that child has been placed with a foster parent, things are going great. We stop looking at 6 months, and that child is, something happens and that child is taken away from that foster parent.
Mm-hmm.
Does this process start over again? Do we continue to look for blood relatives or fictive kin? I mean, I'm just trying to walk this out and see, because I know there are circumstances where someone who is placed with a foster parent is taken away from that foster parent. So what happens to that child?
Technically, you are the child will be within the custody of DFACS at that point. So it would depend on. There's also a track going as far as terminating parental rights and where they're at. And where the biological parents or the caregivers, the initial caregivers of the child, were at in there's a lot of different branches where that child can go. So it would really depend on where the parents were in their case plan, if there was a reunification plan that was in place, and also the termination of parental rights, how that case was proceeding. So there's some variables there.
Okay.
Looks like one more question from Representative Rakestraw.
Thank you, Mr. Chair. So I'm trying to walk me through, based on Representative Raffensperger's question. So during that 6-month period, they're in a temporary foster home. Is that where they put them while they're trying to find?
They're in a foster care placement, yes.
Okay, and so we want as much consistency and stability as possible. So it's better to have 6 months so that they're not being moved around more. Is what you're saying? Okay. So, okay, that was my question. Thank you.
The chair would ask a question, if I may. Just looking at line 15, to me, the word that jumps out to me is the word if. So if the court finds, and then if you look down on line 18, the court finds that, we can't find the blood relative, and on line 18, the removal of the child from the foster parent would be detrimental. And then on line 20, the court may excuse DFACS from continuing the search. It seems to me that while this is a clarifying bill, what it's really doing is clarifying and encouraging options that the court has. That ultimately, the fate of the child in this particular circumstance that the bill contemplates is up to the court.
That is correct.
So it's really just kind of clarifying that the court has these options. If it's in the best interest of the child as determined by the court, and as we know, juvenile court judges, isn't it true, are very familiar with their caseload.
That is correct.
Thank you. Are there any other questions for Chairman Ballinger? Our posture would be entertaining a motion at this time. We have a motion to do pass and a second. All in favor say aye. Like sign opposed. Measure passes.
Thank you, members of the committee. We are adjourned.